This week on Lewis on the Law, I've got yet another great show. I have attorney Crystal Kessler in the studio with me, and we're going to talk arbitration and mediation.
Welcome to Lewis on the Law.
You are listening to Lewis on the Law. My name is James Lewis, and I have another great show for you guys. And in the spirit of empowering you, the listener, that's right, empowering you, we've got a great topic today. I have attorney Crystal Kessler on with me. She is the managing attorney at C. Kessler Law. That's correct, right?
Yes, it is.
And what do you guys do? What exactly is your area of law over there?
So we do a little bit of everything, quite honestly, but specifically what we concentrate on is employment law. We do a lot of employment litigation work for both the individual as well as the small business, and that's things from wage and hour laws to discrimination cases, and to managing businesses to make sure that they don't get involved in those types of suits and to make sure that they have the policies and procedures in place to avoid those issues. So on top of doing that, we also handle personal injury matters. And of course, our topic of today is mediation. So C. Kessler Law, we also have mediation services available for the employment matters, for personal injury matters, and any other general civil litigation matters.
That's right. Our topic today is mediation and arbitration. You know, I wish I'd known you did employment law back then, because my last corporate job, they just worked me like a dog. I mean, they gave me a decent salary, and then they're like, we're just going to work you nonstop. Is that right?
Well, listen, I mean, it depends on what your contract says.
I know, right? I signed it, and I'm an attorney, so they're like...
Exactly. And they probably put in an arbitration clause in there, which we'll probably get into too.
Yeah, exactly. Okay, enough about that. So a little bit about mediation and arbitration. Exactly what are we talking about?
Sure. So a lot of people don't know what the difference between mediation and arbitration really are. And so the main difference between the two is the actual mediator or arbitrator. The mediator is someone who is a middleman. They truly have no dog in the fight, and they're just there to help you facilitate some sort of resolution in whatever case you may have. Whereas an arbitrator is there to do the same thing, but they're going to make a decision based on what they think, right? They're almost like a judge. They're the judge and the jury. Mm-hmm. And so they're going to make a binding decision for you. Whereas the mediator is going to give you an opportunity to have to be empowered and have a peace and sort of be able to determine how we resolve your case. And you get to make the decision as the party, as opposed to being told by a judge or a jury.
Okay, so what happens in mediation then is not binding. But what happens in arbitration is that correct?
Well, it depends on how it is resolved. If the mediation is successful, then yes, it is going to be binding, but it's going to be binding to the terms of the parties. Okay. Right? So the parties are going to decide what that agreement looks like. They're going to help draft it. They're going to help put it together, and it's going to look like what they have compromised with one another to come to some sort of resolution. The judge is going to sign off on the arbitration. Mm-hmm. The judge is going to say, this is the decision that I've made based on the evidence that has been submitted to the arbitrator. Mm-hmm. The mediator is going to say, okay, party A, is this what you want? Cool. Mm-hmm. Party B, do you agree? Mm-hmm. Yes. And if both parties can agree, then the mediator will help you to draft that document. But that document really belongs to the parties.
Okay. So the arbitrator drafts the documents. Now, is the arbitrator, is he part of the court system?
Sometimes they are, sometimes they are not. It depends. Some arbitrators are actual judges, and most of them are typically either retired judges or people who have gone through the arbitration process to become an arbitrator. A lot of times mediators are both mediators and arbitrators, but they wear two different hats. Mm-hmm. There are private arbitration facilities and companies that sort of do that specifically in a private setting. And most of them, they have their own rules and regulations and that sort of thing, but they act like a judge.
Okay, so the private arbitration companies, a lot of times in these contracts that you see that you see these massive contracts like on iTunes, and there's this little itty bitty clause that says something about arbitration. Now, does that go to like a private company necessarily?
It could. Usually there is a arbitration bar, if you will, for lack of a better words, that do a lot of them. There's an American Arbitration, and they do a lot of the arbitration. So it depends on what that clause says, what those little tiny words say. They actually mean something in terms of where it's going to occur. Mm-hmm. But yes, it is sort of more of a private company that is performing those types of services, and typically it's within whatever jurisdiction that the parties are in.
Okay. Now, a lot of people sign these documents and they don't even pay attention to it. I know I do it myself. I'm just like, iTunes, that's a million pages, and I'm an attorney and I still don't want to read it. I'm just like, just give me my music, I'll just sign. So how binding is it when it's like that?
It is typically pretty binding.
Ouch.
Ouch, right?
Careful for what you sign.
Yes. Arbitration is typically pretty binding. And the reason that companies such as iTunes and larger corporations do that, they do it because it helps eliminate some of the costs.
iTunes, we are not picking on you. Don't sue me, please. I have an iPod and all my stuff, all my music on you. So don't sue me. We're just using you as an example.
Yes, just as an example. And in fact, I'm like totally the Apple everything person. So
we love you, iTunes.
But nevertheless, those types of clauses are in place to really help facilitate a more cost-effective way to resolve disputes between, whether it's an employee, or whether it's just an end user to one of the products that's being served. It gives them an opportunity to resolve it without going through the court systems in the traditional sense. And so that gives them another opportunity to resolve without that.
Okay, so when something is actually decided through arbitration, I guess with mediation, I can see that a judge signs off on it. Is that correct?
In mediation or arbitration?
Arbitration or mediation.
See, it depends on which one we're talking about.
Okay,
See, that's the difference, right? So with an arbitration, there is going to be the arbitrator who has the binding ability, similar to a judge, to sign off on the decision that they make. Now, even with arbitration, of course, there's always opportunities for appeals if one party is not happy with the outcome. Nevertheless, the arbitrator does have a binding ability to bind you to whatever order that they come to at the end of it's a semi-trial, right? At the end of your trial, instead of you being in a courtroom, though, you may be in a conference room, and instead of there being a jury, there's just two people on two different sides sort of articulating and arguing their points.
So that brings me to a question. Since it's an arbitrator who actually signs it, does that mean it's enforceable?
It is.
Okay.
It is.
Will
absolutely
the courts enforce it?
Yes.
Okay.
The courts will enforce it just like it would any other order from the courts. Unless, like I said, if there's a dispute as to the order, typically that's going to go through the appeals process, similar that you would in a normal court process.
Okay, so you can just appeal it as if it was a normal court case.
Yes, it can be appealed, and it will be based upon whether or not the issues that you're raising in the appeal, or either A, appealable issues, or B, that the arbitrator did something improper, and the arbitrator will get just as much leadway as the typical judge would get in terms of whether or not they went outside the bounds of their sort of responsibility. And so as long as there is some sort of evidence to justify their decision making, then they're gonna pretty much be upheld.
Okay. And for a lot of our listeners, they don't really understand the appeals process. They think that just the whole matter can be appealed, but that's not the case, is it?
No, it depends on what legal issues are truly at issue with regards to whether the law and the evidence line up, right? I mean, as long as there is some sort of evidence to justify the legality of the decision that the arbitrator has made, then it's not technically an appealable issue.
And I know in court cases, you can only appeal what's on the record unless they look at it fresh, and you can only do that with certain cases, I guess, de novo. I don't want to use too many terms of art because I'm trying to keep it for the listeners here.
Yes. So an appealable issue is typically one that you think the judge got wrong, and they didn't get it wrong because they didn't decide it in your favor, right? I mean, that's what you want to say.
The judge is just wrong. He's just wrong.
That's not the reason. The reason that you appeal an issue is because they got the law wrong, right? I mean, they have not either looked at the prior case law that's involved and how the law has been interpreted in the proper manner, or there's a reason, or there's a rule that they decided not to implement as a part of their ruling process that you believe should have been implemented, and if it was implemented, you would have gotten a different result. So those are the things that we're looking at to determine whether or not it's appealable.
Okay, it's similar to a court case, actually, then.
Yes.
Okay. So we're almost at the end of this segment. Crystal, why don't you give them some contact information for you?
Sure. So C. Kessler Law, we would love to help you with any of your employment matter needs. C. Kessler is CKESLER. You can see us on IG or Twitter at CKLawGA. And you can also, of course, see us at our website at ckesslerlaw.com.
And just a little plug for Crystal here. Crystal was my litigation partner during our mock trials at law school. And of course, we won because we always win. And I like to take credit for it, but Crystal was awesome and carried the weight. She's like, James, what are you doing?
No. Yeah, I had a great partner, and luckily we were able to make some magic happen.
Yeah, exactly. Okay, you're listening to Lewis on the Law. My name is James Lewis. I'm your host this week and every week. If you would like to catch any of my old shows, you can go to my website, jameslewislegal.com, and all my shows are archived on my website. Just to let you guys know, this show is now streaming nationally. You can catch us on almost every large streaming platform, including iTunes, Spotify, and I don't know the names. I'm not hip like the young kids are today. If you have a topic you'd like to hear on this show, go ahead and give me a call at 404-610-0075 or hit my contact page. And if I don't know anything about the topic, I'll bring an attorney on who can speak about the topic. When we get back, we're going to get into the mediation process. You're listening to Lewis on the Law. My name is James Lewis. I am not going to make fun of Sam at all because I like that. I know exactly that band and you should just keep that on the radio broadcast because that is awesome. I have attorney Crystal Kessler on in the studio with me, and we are talking about mediation and arbitration. And a lot of people are confused about these. It seems like they're the same thing, and they're both kind of like alternative ways to resolve a dispute. And so I can be confused about it because I actually volunteer with landlord-tenant issues and for Atlanta Legal and Atlanta Volunteer Lawyers. I can say their name because I've had them on my show, and they're all right with it because they need all the publicity they can get. So attorneys should help out with Atlanta Volunteer Lawyers and Atlanta Legal Aid. But, we go to mediation, usually the first step in resolving a landlord-tenant issue. The judge sends us to mediation. So let's talk about mediation a little bit.
Sure. And landlord-tenant is a great sort of topic to talk about mediation with. It's one of those things, especially if you're in the city, that is typically required prior to you having your case heard before the judge. So with there being a lot of people in Georgia, there are a lot of tenants and a lot of landlords, and so a lot of people can really relate to that topic. So I'll stick with that topic as a baseline for mediation. So when you get to court, right, that means there's been a complaint filed typically by the landlord, and the tenant has answered. And so now we're going to go to mediation to figure out if we can resolve whatever issue that they're having, whether it's unpaid rents, whether there's things wrong with the property that haven't been fixed, whatever the issue may be, we want to try to resolve that, right? Mediation says when I walk into the room for mediation, I'm going to be able to sit in a conference room with the mediator and the other party on one side and myself on the other side as the second party. And I'm going to be able to explain myself to the mediator, and I'm going to explain myself to the other side, no matter what the issues are going to be. And I can do that freely in that room because nothing said in that room is supposed to leave that room. Even if we don't resolve the case, even if we go to the judge right after that and decide to have our trial, nothing that is said in that room is applicable to what is going to be in front of the judge. Okay.
What if the landlord says, I did it. I threw his cat out without giving the cat proper notice?
He picked the right form to tell him because that he is going to be protected. So in mediation, you're going to sign a confidentiality agreement before you even get started. And everyone in the room, including the mediator, is going to be bound to those terms. You're not going to be able to call the mediator as a witness later on in your trial. None of those things.
But mediator, you heard him say it. He ruthlessly threw my cat out, and now my cat is homeless.
So what the mediator can't do is testify to that. But during the process as a mediator, one of the things, if we have sort of that outburst, right, where we've admitted some things, we have a tool called a caucus. And a caucus means that I separate the parties as the mediator, and I put one party in one room and one party in the other, and I as the mediator go back and forth between
Is that
the
because
parties.
they can't play nice? Sometimes you have to separate the kids because they don't play nice? Sometimes
it's because they can't play nice, and sometimes it's because you want to be the tough parent, but you don't want to show any type of favoritism. Correct. So to maintain that neutrality, which is part of our job as a mediator, third party neutral is the alternative term. But to maintain that neutrality, we have to make sure, that we never show favoritism. And the best way to do that is to separate them so they don't see us being hard on one, versus the other. And so you take them to the room and you go, if you threw his cat out, you weren't supposed to do that, right?
Right. I like that. You used my example.
You just ease them on in there and ask them about it. And a lot of times they're like, but he didn't pay, he was $50 short on the rent. And so you ask them, okay, if he pays the $50 that he owes you on back rent, will you go get him another cat? Well, no, it's going to cost me more than $50. Okay, well, are you willing to forego your $50 since you threw his cat? Right? And so it's one of those back and forth conversations that you can have, and you can sort of give them an opportunity to realize that either they're being unreasonable or the other party's being unreasonable. And you do that same tactic in the other room. All right, but you knew your rent was $650 and you only gave them $600, right? And so you can be tough with the parties in a different manner when they're separated, and that's what we do during caucus is separate them and have that discussion. And the best part about mediation is if both parties agree, okay, you don't have to pay me the $50 and then you don't have to give me a new cat, I can put that in a document and the parties can shake hands. We can sign the agreement. I can take it to the judge. He'll say, all right, sounds good to me. And they can go home and they go their separate ways. And they've been able to resolve their case without a judge telling them what to do. Instead, they were in front of it. They were able to make the decision on how they were going to resolve their own issues.
And that sounds a lot easier than having a judge do it and standing in front of the courtroom and the whole deal.
Absolutely. I mean, listen, at the end of the day, would the one party want his cat back? Yes. Right? Did the other party want his $50? Yes, because he filed a whole lawsuit for over this $50, right? So yes, he wanted his $50. Did he get his $50? No. But did he have to pay for another cat? No. And so that's where the compromise comes in, where both parties get to make that decision. Whereas if you're in front of the judge, he was going to say, buy him a new cat, pay him $50, and then call it a day, right?
Right.
Now both parties are angry. And at least in this instance, everybody's not happy, but nobody leaves angry.
Yeah. And being in a courtroom can be nervy. Even for attorneys, it's nervy.
Yes.
And we're used to it at this point in our lives.
Yes. I tell people all the time the reason that I became an attorney is because I was a former athlete, and I like that there's a V in the middle, right? There's a versus. A versus B. It's competitive. Somebody wins, somebody loses, and that's what you get in a courtroom. Yeah. But you don't have to have it that way in a mediation process.
My problem is I always want to win, and I get into the I have to win, and if things don't go my way, I'm not pleasant afterwards.
Exactly. But mediation is literally like a tie, and that's the goal, at least, is to make it a tie with no tiebreaker. Right? So,
exactly.
Everybody wins in mediation is sort of what we try to go with. Which for me as a mediator, the win for me is being able to get two parties on the same page.
Yeah, to resolve their conflict. Okay, so what types of conflicts can go to mediation? Can any type of conflict?
Yes.
Okay, any type of conflict. Do you ask for mediation, or is it forced by the courts?
Depends on the type of case, whether or not it will be forced. The examples that we've been using, landlord-tenant in the city of Georgia, for the most part, in most of the metro counties, it is required that mediation occurs first. But the best thing about mediation is that even if it is required, it's required that you attend. It's required that you give good faith efforts to try to resolve the case. But it's not required that you resolve the case, right? So it gives you an opportunity to sit down with the other party, to hear them out, to understand their side, for them to understand your side, and to resolve the case if you can. And if you can't, you can both shake your hands, wipe your way, and you still have your day in court. You can still go before the judge if you don't, resolve the case. In terms of outside of sort of the landlord-tenant spectrum, it can either be agreed upon by the parties, and typically in most settings, it got to be agreed by both parties, unless it has been issued an order by the judge requiring it. Both parties agree to mediation. We schedule it, we go, and we try to get it resolved. And that's for anything. I mean, the best thing I've seen, Fulton County actually has it for criminal, small misdemeanor criminal charges as well. So that I didn't know that for the longest that was sort of an opportunity for mediation. So it pretty much spreads the gamut of all types of law. Mediation is available for you. Okay,
that's really interesting. I wouldn't have thought of criminal law either, because when you hear of mediation, a lot of times you think of like family law.
Yes. So family law, there's mediators for family law. There's sort of general civil mediators, and then there's also criminal mediators. Criminal mediators and family law mediators require additional sets of CLEs and classes and certifications to be able to do those specific types of law, including juvenile law and that sort of things, just given the nature of those types of cases. But the general civil litigation type of mediation is just the full gamut of everything else that can fall into that.
Got it. So one of my earlier experiences with actual trial was I helped an attorney while I was in law school in a family law case. And the things it's funny because you said good faith, but the things I heard in that room scarred me for life. And I said, I will never practice family law. Oh my God. The things that they said to each other were horrific.
Yes.
I mean, they've got into all kinds of details. I'm just like, oh my God, you're talking in front of other people here.
Yes. Well, mediation is supposed to be the open book room, right? They know you couldn't repeat it afterwards. So they were probably an open book. But nevertheless, C. Kessler Law does not handle any family law mediations. That, like I said, is a very specialized type of mediation. But I know several people who do, and they never have a boring day at their office.
Yeah, family law is if you like drama, that's the area of law for you. That's why I don't do family law.
Me too.
I do real estate law because I don't like drama, and there's enough drama in that for me.
There is. Well, I do a lot of employment law, so I can't really say I don't like drama.
Yeah, there's a little drama in employment law.
You would be amazed at what people do in the workplace.
No, I wouldn't. I've seen it. I've been in the workplace, so I wouldn't be amazed at all.
Oh, trust me. It would shock you the things that people would do in workplace. But
so what type of mediation do you do then? You don't do family law?
No, I do not do family law, but I do any other general civil litigation mediations, including for employment law matters.
Okay.
I've sat on both sides of the table. I've been a defense lawyer. I'm currently sort of a mixed lawyer, if you will. I now represent small businesses as well as individuals. So I've been on the plaintiff side. I've been on the defense side and employment matters. And so I'm able to sort of maneuver both sides of the table well, I think. And so I do employment law mediations. I also do landlord-tenant mediations and any other general civil litigation type of matters, whether it be a contract dispute or anything else like that. So if it's not family law, if it's not criminal law, call me.
Yeah, nice. Those are two areas I stay away from too. Okay, we're almost at the end of this segment. Crystal, give them some contact information.
Sure, of course. You got C. Kessler Law. That's CKESLER. And you can see us at our website at ckesslerlaw.com. Of course, you can see us on IG and Twitter at CKLawGA. That's both tags on IG and Twitter. And of course, Facebook, you can search C. Kessler Law LLC and it'll pop up.
Nice. You're listening to Lewis on the Law. My name is James Lewis, and I am your host for the next 24 minutes. We come to you each and every single week to give you legal information, but if you have a serious legal issue, do not rely on what you hear on this show. Go ahead and contract with an attorney. You can contact the attorneys on air. I let them all give their contact information. You can go back through my archives, and you can pick attorneys that you might think will be helpful to you. What this show is designed to do is to give you your first step in the legal process. If you need to know if you have a case, what type of case it is, what type of issues there are that you might want to be thinking about, or what type of attorney you're looking for. If you need help finding an attorney, you can always contact me at James Lewis Legal. You can email me at james@jameslewislegal.com, or you can give me a call at 404-610-0075. When we get back, we're going to talk about the other part of the subject, arbitration. You are listening to Lewis on the Law. My name is James Lewis, and I am your host this week and every week, empowering you, the listener, with legal information. And this show is a great show, and this next topic is great because it's about arbitration. I have attorney Crystal Kessler on with me, and we're talking mediation and arbitration. But every time I hear arbitration, I immediately think arbitration clause and those tiny little clauses in those huge contracts.
Yes. So arbitration, what is the difference? We've talked about mediation, where you are empowered as the party to make a decision for yourself and to sort of compromise and make a resolution for your case. Arbitration is a little bit different. Arbitration is essentially taking your case outside the realms of the typical legal spectrum in terms of the courtroom and that sort of thing. And you're really just placing it in a conference room for a mini trial is what we call them. And so essentially what you are doing is you are trying a case just like you would You have witnesses that swear under oath and give testimony. You provide documents to the arbitrator, but the arbitrator is judge and jury. I mean, that's sort of the short end of it. He's going to make all the decisions in your case, right? You're going to give him all your evidence. The other side's going to give all their evidence, and then a decision is going to be rendered. And he's going to order and issue an order that is binding upon you. And especially if you sign one of those contracts or accepted one of the services that had one of those clauses in it.
There's a lot of them out there too.
Yes, that required arbitration. And I think we'll talk about a little later on why those are in a lot of places that you see. But nevertheless, that is what arbitration is all about. It's the short route to the end goal, which is to get a resolution. And so, yes, it is, taking it out of the realms of the court, so you get there quicker, and that sort of thing. But at the end of the day, you're not in complete control in terms of how you resolve the case.
Okay, so what types, and we're going to get into the what again. What types of case go into arbitration? Are they only the ones where you sign a clause that basically allows yourself to put into arbitration, or are there more types of cases that go into arbitration? And what types of cases specifically?
Arbitration is open to
everything.
Everything.
Even like criminal cases?
Well, mostly civil. I mean, 9 times out of 10, it's going to be a civil case. Where it is not the state as an actor. It's going to be 2 private parties that are going to go into arbitration. So yes, you can go into arbitration for pretty much anything. And so the reason that you may do it is because you signed a contract that said if there is a dispute that arises out of this contract, we will go to arbitration, and then a dispute arises out of this contract, right? So now you're going to arbitration, and that may be why you're there, or it may be that both parties are typically sophisticated parties will decide, listen, I know we didn't sign any arbitration clause beforehand, but let's agree to arbitration now. Because that's in the best interest of both parties for a quicker resolution, for a cheaper resolution, to sort of just get this over with, if you will. And so that gives them an opportunity to do that. And with arbitration, it does, the arbitrator does have a little bit more leeway in how they resolve cases than your typical judge. But for the most part, they follow the letter of the law as well.
Okay, you said there were private arbitration companies. Are there other types of, is there something besides a private arbitration company?
Not really. I mean, there are associations similar to like a bar association. They're sort of self-governed in a sense.
But they're still private companies.
They're still private. Okay. Yeah, they are private. But I mean, a lot of them are either former judges who have actually been judges in the court of law, whether, depending on the state or magistrate court or state court judge or federal court judges that are now retired, and that's sort of their next step in their career is to just be an arbitrator, to sort of back out of the courtroom a little bit. Some of them have just gone through the process to become an arbitrator, and they're arbitrator, and typically they were previously mediators or attorneys or things of that nature.
Wait a minute, typically are some of them not attorneys? I would hope they were all
not
attorneys.
All mediators and arbitrators are attorneys.
Oh, well, that is something I actually did not know.
Mediation does not require you to be an attorney.
Okay.
Yeah.
That's worrisome.
Yeah, well, I mean, you do know that some judges in the state of Georgia are not attorneys.
Yeah, I've heard that. I'm not really quite sure how that works, because I thought there were like time requirements for you to serve on the bar before you could even be appointed judge or run for judge.
Depending on your little county, there's not enough persons or attorneys to sort of go around.
Now that I do know, there's at least 5 counties in Georgia where there's not one single attorney.
See, there you go. And so usually they appoint the local businessman or your local
guy.
banker or your local,
Don't appoint the bankers. I'm on a banker rampage right now. Whatever you do, don't appoint your bankers. No, I'm just kidding. I love you, my banker, who I'm not going to name at this point.
But yeah, so it just depends. You don't have to be an attorney. Majority of them are. Majority of them are attorneys, or at least have gone to law school or some sort of legal program. But all of them are not. As a mediator and arbitrator, but just you think about it, nobody, or typically, most of your jurors are not legal minds, right?
That's true. That's true.
Your alternative is 12 random people who don't have any type of legal background. Making a decision for your case, and that's in the justice system, right? That's what we base our justice system on, is those jurors, and they're not of legal stature, if you will. So it's the same thing as a mediator and arbitrator, and especially in the mediation realm, because you're not making the decision based on legality. You're making the decision based on what the parties need and want. And so that is why it doesn't really matter, truthfully, if you're doing it the right way, whether or not you understand all of the legalities of each case that you mediate or arbitrate.
That is something I actually did not know. It feels worrisome that an arbitrator without a legal degree may come up with a legal decision, a legally binding decision.
Well, most of them are. Most arbitrators are. Let me just be very clear. Most arbitrators are.
I thought so. So you surprised me with that one.
Most arbitrators are, but most of them go through a second series of training to become arbitrators, and most of the private arbitration groups that require it as well, which is why most of them are. But you can become a sort of a private arbitrator if you wish. I am not an arbitrator. I typically like the mediation realm for me. But so I'm not an arbitrator. It's not my way of doing things. But arbitration is definitely a big part of ADR, alternative dispute resolution, and so it's definitely necessary.
Okay, so what on these little contracts, these arbitration clauses, is it the company that gets to pick the arbitrator? I mean, do you have any says? I mean, once you sign those, are you just at their mercy? Do they pick the company, they pay the company, and then all of a sudden you're at their mercy? Typically,
they pick the organization, in which is, like I said, they have an American Arbitrators Association, and they typically, or JAMS, have some arbitrators. There's major ones. It's sort of a monopoly out there, if you will, of the arbitration group. So there's not that many to choose from. And so in terms of the organization that is going to handle it, and then once it gets in there, it sort of just falls in the hands of an arbitrator unless they specified in the agreement the who, what, when, where, type of thing, which most of them don't. Most of them just choose this, group, whatever group of arbitrators, and then the arbitration community would choose, or the company would choose, sort of assigning. Just like you would get assigned a judge, you're assigned an arbitrator.
Okay, and I'm going to go back to those clauses that you sign. So when you sign it with like one of the big international companies, and I'm not going to name any company, I keep wanting to, but I realize I should not do that because I can get myself in trouble. And this is why the big law firms, they'll let their attorneys come on, but they're like, whatever you do, don't tag us because I don't know what he's going to say.
Yeah.
And okay, who pays for the arbitrator when you sign one of these deals? I mean, you're Joe Schmo. You got 25 cents in your pocket, and they ripped you off on your favorite soft drink, and you're like, I need relief, and you're forced to go into arbitration. You don't have money to pay an arbitrator. Who pays?
It depends on what your clause says. One of three things could happen. The company can agree to pay. The individual can agree. It can say that the company is going to pay. It could say that the individual is going to pay. Most of the time, it says that each party is responsible for their own fees, and essentially that means you're going to split them 50-50. And some of them say the prevailing party pays. So whoever wins in arbitration pays.
Ouch.
Right. Whoever wins in arbitration, the loser, has to pay. The prevailing party, is costs are taken care of as a part of prevailing in the case. So, if you lose in arbitration, you may be stuck not only with whatever bill you're stuck with because of the judgment that has been issued against you in the case, and you're also stuck with the attorney's fees and costs associated with that, which would be inclusive of the arbitration fees.
Ouch. You want to be careful of something like that.
Yes, but the arbitration fees are probably going to be a lot less than the attorney's fees and costs that you would have had in the same scenario, except for you went through the traditional, legal realm.
Well, that sounds like kind of a positive. I don't know. I still am a little suspicious of the arbitration route, especially when it's forced upon you.
Well, like I said, a lot of companies put those clauses in their employment contracts and their service contracts because it is a more cost-effective way to handle claims. And the bigger the company, the more likely they're going to have claims, right?
Lots of them.
And so to sort of reduce the amount of damages, you go to arbitration. And to be quite honest, an arbitrator is less likely in sort of the way it plays out. Even if the company loses in arbitration and they owe the other party some type of money, arbitration has often rendered smaller verdicts or judgments than typical juries will give. Yeah. So that's another reason that companies like them, is because if I go to a jury, then I may have a $50,000 judgment as opposed to a $20,000 judgment by an arbitrator. So take my chances with the arbitrator.
I actually like juries for that exact same reason. I feel like I feel like I'm fairly charismatic and people tend to like me. So I'm like, I want the common people to hear what I have to say.
Yes, which is why most individuals don't like that they have signed an arbitration clause.
Yeah, exactly. We're at the end of this segment. Crystal, give them some contact information for you again.
Sure. It's C. Kessler Law. It's CKESLER. And of course, you can see us at ckesslerlaw.com, our IG and Twitter at CKLawGA, or you can reach us by 470-371-6408.
You're listening to Lewis on the Law. My name is James Lewis, and I want to remind you once again that this show is now streaming on every single national platform that you can think of. You can go to iTunes, Spotify, and guess what? We are also AI compatible, so you can go, hey, Alexa, play Lewis on the Law, episode 45 with attorney Crystal Kessler, and wham, this show will pop up, and you can't get more friendly than that. We're here to give you legal information. We touch on a lot of topics. You can search the archives on my website and hit different topics. And, it's because there's no music that I keep rambling on. When we get back, we're going to talk about the costs and the benefits of alternative dispute resolution. You are listening to Lewis on the Law. My name is James Lewis, and I am your host this week and every week, empowering you, the listeners, with legal information. And once again, I have to throw out this disclaimer. This show is not meant to present legal advice. If you have a serious legal issue, go ahead and contract an attorney. If you have a serious employment law issue, you can contact Attorney Kessler here on Law. She's Crystal, give them contact information for you once again.
Yes, of course. You can reach us via phone at 470-371-6408. You can also send us an email at info@ckesslerlaw.com.
If you have a real estate dispute or a real estate transaction, you can always give me a call, James Lewis at jameslewislegal.com at 404-610-0075, and I would be glad to help you. If you need an attorney, you can search through my archives. There are a bunch of attorneys in different areas on my archives, or you can just give me a call at 404-610-0075, and I will help direct you towards the right attorney. Now, we got on this show, we throw out a lot of legal stuff. A lot of it hits these listeners quick. Can we get a little recap, basically, on the whole thing, on mediation, arbitration? What's the difference?
Sure. So mediation is going to be empowering the people, right? Empowering the parties.
I love that. Empowering the parties. That's what it's all about.
Empowering the parties. Mediation is going to be you.
Wait a minute. Is this like mediation good, arbitration bad? Maybe not so simple.
It depends on your case, right?
Yeah, okay. So that's the attorney answer. Well, it depends. Wait a minute.
It always depends. It always depends. Mediation, empowering the parties. The parties are going to make the decision. The mediator's there just to facilitate the process. When you're talking about arbitration, you are talking about a more straightforward, to the point legal process where there is an arbitrator that's going to make a binding decisions on the parties. And so that is the main difference between the two. Arbitration is quicker than regular court. It's going to be less costly than sort of going through the gamut of regular litigation. But you are going to have one individual, one judge, being judge and jury and making the decision in your case.
That sounds dangerous to me.
It can be. It can be.
What was that comic book guy, Judge Dredd or something like that? I'm judge, jury, and executioner. You want to run into that arbitrator.
That's essentially the arbitrator. The mediator, though, is just your friend. Your mediator is helping you to facilitate the process, to make sure that you and your other parties understand the issues and try to come to some sort of resolution in that.
Well, that sounds like a much better thing. For some reason, mediation to me sounds like the simpler, less painful task.
Well, I'm a mediator, so
so you're biased in that direction.
Which is kind of a conundrum, since mediation is about being a neutral. But nevertheless,
you should be neutral in this.
But I'm totally biased. I do like the mediation process, because the mediation process is typically not forced upon the parties. Even if it is forced upon the parties, they're not forced to make a decision at that moment. So it gives like I said, it empowers the parties. And so I enjoy sort of putting the power back into the people.
Okay, now let's get into some benefits of alternative dispute resolution. We've already kind of touched upon cost, but is cost really a benefit? Don't you still have to have an attorney and pay him mad bucks?
Yes, cost is a big factor. So one of the things with cost, I mean, yes, you're going to have your attorney's fees, you're going to have, your mediator cost and that sort of thing. But if you mediate early, which we're talking about alternative dispute resolution, and typically you want to mediate early in the case. And depending on the case, you can mediate before the case starts in litigation. You can mediate during the midst of litigation. You can mediate right before it heads to the jury if you want to. And so you can sort of mediate at any point in time in the process. And
Wait a minute. Is arbitration, is that similar? You can arbitrate during any point in time during the process?
Well, you don't get the litigation process with arbitration, right? You're going
right.
straight to the arbitrator, and it's going to be sort of a mini discovery period and a mini exchanging of documents.
In arbitration, I guess there's also the discovery period and depositions and the whole thing. I mean, maybe not so.
It depends. I mean, yes, a lot of times you're going to have an opportunity to do some of that, but it's not going to be in the typical form that you would normally do depositions and that sort of thing. And typically you're getting a lot of witness statements and exchanging of documents between the parties before the arbitration. It really just depends on, again, cost analysis on how much you go into that, because again, the benefit in arbitration, if you're the plaintiff seeking, monetary damages, is going to probably be less than if it's in front of a jury. So you have to sort of weigh that cost risk analysis when you determine how you're going to gather all of your evidence and things like that.
So it sounds like arbitration is definitely good for the bigger companies because of that cost reduction. But,
yes.
But it feels like it may not be as good for the little guy.
Well, for the little guy, the benefit I would say for the little guy is quicker.
Okay.
It's going to be quicker. When you're talking about someone who has been wronged, they want immediate results. And as a attorney, it's sometimes difficult to give them the immediate results that they want. With arbitration, it at least makes that process a lot less timely than a elongated year in, year out type of litigation that can last 2 to 3 years on average with civil litigation. So, instead of waiting those 2 or 3 years, you get it a little bit quicker.
Okay, so are there some non-monetary benefits to this?
Absolutely.
Okay, there are. Okay.
Yes, there are absolutely non-monetary
I thought it was all about money in this world. Money makes the world go round. No?
It does in the legal profession, right? Especially in the civil legal profession, it definitely does. So when it comes to the non-monetary benefits, mediation, and I'll sort of talk about mediation in particular, but mediation allows you, the parties, to be empowered. The judge has a set of rules and regulations and laws that they have to follow and principles that they have to follow. And so they're only able to give, in most cases, money, right? That is the damage that they're able to give. Now, there are some specific performance type of damages, and I won't get into all the legalese of that. But you and I both know you can give some property and, that sort of thing when you're talking about things like that. But nevertheless, if we're talking about a basic, going back to our landlord-tenant from earlier in the segment, if we're talking about basic things such as, I just want them to come fix the air condition.
There's a lot of that goes on.
My rent, if you would just fix my air condition, right? The judge can't say, hey, fix the air condition. The judge can say, you violated the lease because you were supposed to, as the tenant, as the landlord, fix the air condition. They don't have to pay you X amount of dollars, or you owe them X amount of dollars as a result thereof. That's all that the judge can do. It's only a monetary benefit that they can give. But in mediation, you can say, I will pay you your rent if you would just fix the air condition. And I can put in their mediation agreement, he's going to fix the air condition by June 31st or June 30th, right? And that is the agreement. That is a contractual agreement that he is abided by, and we can enforce it by the courts, but that he can agree to. That's non-monetary in terms of, he don't want you to hand you over a check. I just want you to fix the air condition. And so those sorts of things can be non-monetary benefits of mediation. And sometimes, the biggest non-monetary benefit of mediation is sometimes an apology.
An apology? Wow, I've never had a client that wanted to settle for an apology.
Yeah. I've had clients who literally, they were willing to take, thousands of dollars less if they could just receive a sincere apology.
Wow, that is something.
And you can't force anybody to give an apology, right? But mediation is an opportunity for you to say, listen, you could save some bucks if you would actually just give them the apology that they need. Acknowledge that you did something wrong. Acknowledge that they were hurt because of it, and acknowledge that you're sorry. And that will help resolve. I'm so serious when I say this. That will help resolve majority of the issues if people would just apologize.
And I think a lot of litigation is just, their temper tantrums and we're all kids in adult bodies, and there's a little kid inside of all of us, and the little kids in each other get upset. And, because if we were all just rational, we could resolve a lot of these things.
I'm so serious. There's a lot of litigation that could be avoided if there was an apology, and an apology can be a part of a mediation agreement. Or for instance, if it's not the apology, if it's one of those things I've had, because I do employment work, a lot of times the employee is like, there are a lot of things that they do, and if they would just change these policies, they wouldn't run into these issues. And I just don't like the way that the other employees there are being treated too, because they're having the same issues I am. I'm just speaking up about it. And all they want is the change in policy. And so that's a non-monetary, and it really doesn't even affect that person, because typically they're no longer working there, right?
Yeah.
But they just want to know that moving forward, their coworkers, their former coworkers, are not enduring certain things based on policies and procedures, and they want to know that there's going to be a change in policies. That's something that you can decide in mediation, but that's not something a judge can force upon a company, right? So those are the types of non-monetary benefits that I had never
thought of that. You're right. Sometimes they just want an apology, and a judge can't say, apologize.
No. Yeah. So that's another one. Apologies is a big, like I said, policy changes in the employment realm is big, or just the last thing that they allow, especially in employment, is I need a neutral reference, right? We did not end on good terms, but I still need you to give me a neutral reference.
No. That is solid. That is solid because I know people like that. They're like, I just need them not to say anything bad about me.
A neutral reference is the number one thing that number one non-monetary thing that we have in mediation and in any type of employment agreements or resolutions.
And that can be worth money in itself.
Yes.
Crystal, we're at the end of our show. So once again, give them some contact information for you.
Sure, of course. It's C. Kessler Law. You can reach us at ckessler, CKESLER, law.com, or you can reach us via IG and Twitter at CKLawGA. And, of course, you can reach us via phone, 470-371-6408, or email info, at ckesslerlaw.com.
You're listening to Lewis on the Law, and just before I leave, once again, I have to thank the guys that make the magic happen. Mr. Sam Davis over there pushing the knobs and poking the buttons or something like that. And Mr. Anthony Cook, who is always doing a great job with the video content. You're listening to Lewis on the Law. I will see you guys next week.